We have a quorum. East, you won't be here either. We got 2 absent. It's now 3:30. We can start the meeting.
I call to order the Independent Ethics Review Board on Thursday, May 11th, 2023 at 3:30 p.m.
Okay. Yeah, I just dumped it here. Wait a minute.
I think before we start, Robin had a few housekeeping items for us.
Well, if you want to go ahead and take roll and
Okay.
establish a quorum, and then we can do that.
Ann Malika is not here. Raquel Roberts. Here. Steve Traley.
Here.
Rachel Varghese is not here. Ted Lieb.
Here.
Andrew Wolf.
Here.
Larry LeBeau.
Here.
Chris Crosby.
Here.
And I, Krista Stegmiller, am present as well. At this time at 3:32 p.m., I would like to call the public hearing to order.
We do have a few housekeeping matters. So my name is Roberta Cross or Robin Cross. I'm appointed counsel for the Independent Ethics Review Board. Housekeeping matters include that for purposes of the hearing today, that the board intends to hopefully be able to complete the matters listed on the agenda. And to that end, there was a fair amount of leeway given at the last meeting as to information that was provided during the respondents' testimony. And that's going to be somewhat limited today in accordance with the provisions of the policy that governs the board. And focus in on what is germane and relevant to the complaint as alleged. Additionally, prior to the hearing today, I received an email inquiring about ethics complaints that were verbally made during the hearing during the previous meeting or at the previous hearing. There's a process that the city has developed under its policy for anybody that wants to file ethics complaints, and making verbal allegations at a hearing does not follow that process. So if anybody wants to make complaints about ethics, one needs to follow the city's ethics policy in order to do so. Let's see the script for a second, please. We also had a number of people speaking from the floor, which happens in a lot of public meetings, whether they're city council or planning and zoning. But in order to stay on track today, there is a provision for public comment. People want to comment prior to the board deliberating, they certainly will have an opportunity to do so and come to the podium and speak for the allotted time. And so would ask that you refrain from speaking from the floor, which disrupts proceedings and is not conducive to efficient processes. Okay.
Those witnesses who have previously testified are reminded that they are still under oath. And the witnesses who have not previously testified that are here today, if you could please step forward. Nice, Stacey.
Raise your right hand.
And you will raise your right hand. And do you swear or affirm that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
So at this time, the board would like to call Matthew Gallagher. He is the board chair for planning and zoning. We thank you for being here today.
Just tell me where you'd like.
Right here at the podium, if you don't mind. And then again, consistent with the policy that the city has, the board is the one that's entitled to ask questions. So board members may ask questions of this witness, including you. There's some sample questions that you want to ask.
Well, if you will start off, I'll pass it over to you initially. If you give just a high level overview of planning and zoning, the role in which you play and the decision-making process.
Sure. So good afternoon. My name is Matthew Gallagher. I'm the current chairman of the Planning and Zoning Commission for the city of Sugar Land. I was appointed, I believe, in 2018, and I've served as chairman since the latter part of 2020. So for about the last 3 years. As far as the purpose and function of the Planning and Zoning Commission, and I hope it's okay if I refer to materials here. The
Fine with
purpose
that.
and duties and responsibilities are both listed on the City of Sugar Land website, and they're also included in the city charter. So generally, the Planning and Zoning Commission makes recommendations to City Council about land use issues and other types of planning issues. In order to promote orderly development within the city of Sugar Land and to make sure that the interests of all the citizens of Sugar Land are protected by that development. We really have about 4 other specific functions that we're frequently called on to do. One is to approve or disapprove subdivision plats. And in that respect, we are the final arbiter. So we actually approve or disapprove plats. The other things that we do, I would say, are in an advisory capacity. We make recommendations of approval or disapproval to the city council, and then city council can accept those recommendations or they cannot. They are free to make their own decisions on the issues that come before them. And typically those issues are proposed changes in zoning or zoning maps. We also comment on the city's master plans. We also review and have an opportunity to comment on the 5-year capital improvement plan. And we do anything else that we are asked to do by city council that might involve attending the Texas American Planning Association convention. It might be sitting in on participating in other task forces, receiving other information or things like that. And then from time to time, there are some other things that the ordinances require us to do that I don't think are an issue here, but there are some other capacities that we could serve, but we're either asked to do that by council or there's an ordinance or a state statute that gives us the authority to do whatever it is that we're supposed to do.
Thank you. I want to open it up to the board and other board members to see what questions you may have for Mr. Gallagher here today.
I have one question. When you say that the authority of the board is to approve or disapprove plats, now that is the only, I guess, governing ability that they have, and the rest of it is suggested. So what would approve or disapprove a plat? What would disqualify a plat?
So that one, there were some recent changes in state law a few years ago that limit what we can do or not put on plats. And I don't have the development code sections in front of me, but generally at high level, if we received a plat and there was missing information on the plat, the legend items that were called out in the legend were inaccurate. You know, if we knew that, for example, maybe it didn't show an easement or something, or that maybe it said overall that the plat was for a certain proper area, and from looking at the drawing itself, you could see that it's not. So if there were technical issues with the plat, but we are somewhat limited in what we can do with plats. But basically, I would say we're reviewing them. We are providing comments. But at the end of the day, to approve or disapprove a plat, it's got to be missing some of the information that's required to be there under the development code. And if it's missing, then we can either approve it, or we can either approve it with a recommendation, or we can disapprove it with a recommendation that it be fixed. But there's even some newer constraints there under state law as to what we can do.
Okay. So a clean plat without mistake should just pass through. That would be,
Yes, sir. We pass that. It gets drawn up and at some point after that, I sign it and that's it.
All right, thank you.
You know, just like this board, P and Z are volunteers, citizens. In your opinion, what qualifies you to be a member of P and Z?
For me, not much. You know, I would say this, so I got involved, I went through the Sugarland 101 program in 2015, and many of you may have gone through that program, but I had interest in public service and rotated through some of the departments, and certainly planning was one of those things. For me, I'm an attorney in private practice. I don't know if what that qualifies me to do, but I feel like everyone on the commission brings a different skill set with them. For me, in my role as an attorney, I feel like I'm pretty good at reviewing written documents, maybe plats, for example. When we had things before us like the proposed land use plan, you know, we've got some stuff before us right now where I would say wordsmithing, I think is, you know, something that personally I'm good at, but I find that each of the commissioners bring their own strengths, whether or not that's some particular background or expertise they have, or it can be certainly expertise that's developed based on years of service to the commission. I mean, you start seeing the same things time and time again. And then in my capacity as chair, I have to run meetings and I try to do that in an orderly fashion as well.
What would disqualify you from being on the board? Is there any, and let me, I guess, elaborate a little bit, is there any profession out there that you would think wouldn't fit the board?
No, I would say no. I mean, clearly, as you all are well aware, I mean, there are ethical guidelines that are out there regardless of the profession. You know, as a current commissioner, there would be certain things that I could or could not do relative to appearing before the commission or appearing before city council or lobbying, you know, on behalf, but not just inherently in my case, because I'm a lawyer. And I don't think your profession automatically disqualifies you in any way that I can think of, as long as you serve within the ethical boundaries that are required of you. And we take an oath too, to, you know, uphold the Constitution and the laws of the city.
Okay, thank you.
When you started on P and Z, you made aware of an ethics policy that the city has governing you?
Yes, absolutely. We're made aware of ethics and we do annual ethics training as commissioners and board members.
Everybody on P and Z does that same training?
Every year. Yes, sir.
Hi, so you laid out really the scope of what is what commissioners can approve, disapprove, and then you also describe conditions under which only recommendations are allowed. During your tenure as chair, have you ever observed any commissioner step outside of what they are authorized to do?
Not in terms of acting on an item on our agenda. I mean, like any meeting, sometimes as the chair of the meeting, you want to try to keep people on task. You want to make sure that the comments are limited to items on the agenda. So we've certainly had stuff like that before, but we haven't had a situation that I can think of where someone has acted on an agenda item, you know, in a matter that's inconsistent with any of the rules or their obligations, if that's what you're asking.
So within this complaint, there was a specific project or initiative, the Imperial Project. Can you give us a little bit of a background as far as what that entails and, you know, a little bit about the status of that?
Yeah, I'm smiling because I'm going to only do that at a really high level. But so many of you are probably aware with the Imperial redevelopment project. I will tell you that from a P&Z perspective, what I believe was in front of us when we considered that particular item was what's called it's a plan development. In this case, it was a preliminary development plan. And so a plan development is, I would say, it's a zoning tool that we have at our disposal to utilize, and it's not unilaterally by us. I mean, it's on request from either the applicant or the city, but where that typically comes into play is, you know, you have your standard zoning categories. You may have something that's zoned residential or maybe zoned business. When you want to do a mixed use development, like have residential and commercial in the same deal. Currently, under the zoning ordinances, the way you do that is through a plan development. So this particular proposal involved what I would say is the investment in and restoration of the Char House, and then also a preliminary development plan for the property that was at issue in that particular plan development. I don't have that in front of me, but in those materials, there's a map for it, so you can see what's under consideration there. And so we were asked to review the information that we were provided as commissioners and ultimately make a recommendation to City Council as to whether or not we approve the preliminary development plan. And there also may have been in there an amendment to the land use plan that related to the number of multifamily units that could be developed in that area. And so again, on both of those, we voted, I think, all at the same time, but we voted to make a recommendation to the City Council. And my recollection from that is that it was a 4-4 vote, which is considered to be a denial, which requires then a supermajority of City Council in order for it to carry forward and move forward. And my understanding is that's what happened. So it was 4-4 in P and Z, and council did reach a supermajority in order to pass that and move forward.
So when you use the term recommendation, is this referencing the role that you played that you outlined initially as an advisory capacity?
Yes. So we're basically saying to City Council is we've reviewed the material, we have heard, depending on what was presented to us. In this particular context, I think the meeting was several hours long, probably about 5 hours plus. So we had all the information that city staff provided to us prior to the meeting. We listened to all of the public comment. We had an opportunity to ask questions of the applicant and city staff, and based on all those factors, we made a recommendation, which again, at the end of the day, is an advisory. As you said, we're telling City Council whether or not we think that ought to move forward or not.
Thank you. One of the items that was brought up at the last hearing, or the last phase of this hearing for discussion, was occupation of commissioners. To your knowledge, or in your experience, is it common to have realtors on the commission? Is that something that obviously it's current, but is that something historically that has occurred to your knowledge?
I can only answer that back to, I guess, 2018 or so. And my answer is, I don't know. I don't know what the occupation were of all the commissioners that I've served with. I mean, I can tell you we've had a variety, the ones that I can think of. We've had people that were involved in as developers. We've had people that were surveyors. We've had people that were engineers. We've had people in the medical profession. I'm an attorney. But I can't say honestly that I recall the profession of every single person that's been on P and Z during my tenure, but fair to say a variety.
That clarification helps. Thank you.
Good question. As far as the just prior hearings or prior recommendations that were made, were there cases where commissioners had to recuse themselves? And in those cases, can you describe the nature of those instances?
Sure. So not in connection with this particular agenda item, obviously, but this is one of the things that we get ethics training on every year. And I will be at a loss to tell you what the exact rules are, but from my general understanding of that is if you believe that for whatever reason you shouldn't participate in a discussion over an item, so maybe that and then what you're supposed to do is you're supposed to notify the city attorney. And if in fact there is some kind of a conflict of interest or something like that, that there's a process for that. So I would say you notify the city attorney, and then the instruction generally is that you leave that portion of the meeting and play no role in those deliberations. So I won't go into like what those circumstances are, because even if, let's say, you're a property owner that's directly affected, I mean, as a property owner, you still have some rights. And so the best practice would be to consult with the city attorney and talk to them about whether or not whatever your issue is does in fact constitute a conflict of interest and something that you should recuse yourself from. So they're there to give you that advice. And if you're in doubt, you should probably check.
So in all of your time, you haven't observed, or could you just confirm if you've observed instances where members had to recuse themselves?
Yes, there have been instances where members have recused themselves from participating on certain items.
Was the vote to accept a proposal or just to say this is something we should definitely consider doing?
The vote is technically to make a recommendation of approval or disapproval, depending on the motion. In this case, the question that was called was a motion to make a recommendation of approval to the city council for the plan development, preliminary development plan, and for the amendment to the land use plan. So that was the motion, but it was a 4-4 vote. So that doesn't end up as that is not a recommendation of approval. It's treated as not being approved. And that's why a supermajority then on council is required to advance the item.
Is it common to have a split vote on items like that, or is it usually unanimous? I mean, what's the kind of the lines on that?
I would say that I think that's probably the first tie vote, and in fairness, we usually have an odd number of commissioners, but at that particular time, we had 8 commissioners. There have been probably 1 or 2 other close votes before. I would say a lot of the items that we take up don't end up being necessarily that close, but obviously with this particular item, there was a lot going on. There was a lot of public comment. As I said, it was about a 5-hour meeting. And it's an issue that a lot of people have strong opinions on one way or another. So having it that close on this issue didn't surprise me, but that's probably more the exception than the rule for the types of things that we take up. But it depends on the issue. I mean, there are certainly cases where there may be 2 or 3 people that have a different view on a particular item. It just really depends on the item. I mean, some are candidly more controversial than others.
Any other questions from the board at this time? Thank you so much for taking the time to speak with us today. We
Certainly,
appreciate
thank
it.
you.
So is this witness recused?
Yes.
Okay.
No,
No,
excused.
excused, recused. Thank you.
Yep.
You done? I'm just.
At this time, the board is going to go into executive session to seek legal guidance.
Are we going?
They don't have to say integration. You say to the audience, I'm afraid that's. We have that. We have a second room. I don't care how you do it.
We use the Brazos room.
Okay, we could use the Brazos room rather than they in the audience. That's fine.
That way everyone.
But this door, interestingly enough, is locked, so they shut it all the way.
We are reconvening the public hearing at 5 p.m. Oh, we are recessing from executive session at 5 p.m. We are moving back into public hearing.
Entire caption. Read the entire caption for the executive session.
Sure. Maybe.
Sorry.
Okay, so we are recessing the closed executive session as authorized by chapter 551 Texas Government Code in accordance with section 551.071 consultation with attorney.
That's it. Okay. And now you can say that you're going back in.
Yes, and now
Okay.
we are going back into public hearing.
Okay, so. Up to you, whether or not there's,
Yes, so we are to the point where we would allow the respondent, Ms. Patel, to give a brief closing summation of your case. We have a 3-minute time parameter. You wish to do so?
oh, there was,
I
okay,
was not told this in advance. I didn't prepare for that. I was told I have all the time I need to respond. I was interrupted last time because she had another appointment. It was not posted and we had to end the time on the building.
okay, so. I think the question is whether or not the board has, any, previously, at the previous meeting, the respondent testified for about 45 minutes. Okay, the standard is whether or not requested witnesses and evidence are relevant and relate to the allegations and are not repetitive of the evidence already presented. And I guess the question is, do you have any additional documentary evidence
Okay,
or
so-
witnesses?
I mean, when you speak about relevance, okay, I could also say Matt's testimony was not relevant to the video that was filed. So I would like to take the time.
Okay.
Sorry. I would like to take the time to go through what I have prepared.
Okay, so respectfully,
And I'll do it as, if I can skip, if it's repetitive, I will. But I
so
need to go.
respectfully, it's within the board's purview to determine, and I didn't write this, it's the province of the board to ultimately determine the relevance of any particular evidence, credibility of any testimony or evidence, weight to be given, and whether or not they feel they want additional information. So that's on the board.
So I'll ask the board at this time if any additional information that you feel is needed outside of that time parameter or additional testimony.
I have new evidence.
So perhaps we start with the new evidence first.
Okay. And is the evidence repetitive? Or what is the evidence?
I'm going to go through the testimony of my complainant.
Okay, that's repetitive because.
In your opinion,
No, it's pretty clearly repetitive
I-
because the board gets to ask the questions.
okay, it was you who decided to stop the meeting last time because you had another engagement. It was not posted on the city website. I've been to many public hearings. They've never stopped, okay? We stopped because you had another engagement. The city website did not say there was an end time. I deserve to have my time. You have taken 2.5 months of my time. 20 minutes is not going to cause a lot of harm.
So it's the board's determination whether or not you want, what evidence you want to allow the respondent to provide information. That's up to you.
Well, I don't know how long, I didn't time myself. You're basically questioning my ethics and character. I have the right to defend myself.
So definitely appreciate an impassioned response and the subject
And
matter.
I'll do my best not to repeat.
It just,
Okay.
in respect
Yes.
of that and out of respect for the time that you've incurred thus far, we want to have ample time to have deliberation.
Yes,
So that we could
I
come to
agree.
some sort of a resolution as a board
Yes.
today and not continue this on for you and for your
I
benefit.
agree.
So in that vein, I'm happy to hear the additional information.
Okay.
But if we could be mindful of time to allow the board to deliberate so that we can come to a decision at this meeting
I will
today.
go as fast as I can. How about that? I will try to go as fast as I can. Good afternoon. As you know, my name is Sapna Patel, and I'm here before the board again in response to the frivolous complaint filed against me by the mayor of Sugar Land, Joe Zimmerman. I'm going to take this opportunity to add to my testimony that was given on April 25th. Before I start, there was a request before this hearing during the hearing after, which I had requested Steve Traley and Andrew Wolf to be recused. And I had given it in the writing last time and gone through it. I wanted to know, was that considered?
Okay, I believe that the indication at the beginning of the meeting was that if you have a complaint, it's up to appointed officials to recuse themselves, not up to members of the body or anybody else to recuse them. And if you have ethics complaints, you need to follow the procedures established by the city.
So that should have been that should have been sent to me when I sent it in the very first time before you guys met the second time. That
In
not
your
the last
opinion.
day when I don't have chance to do it. Okay, that's fine. Okay, so the next thing is, you know, a lot of this things I saw related to my position on planning and zoning, which was respect to amending the land use plan, where myself and 3 other P&Z voted no to amending the plan. I would like to show a video where I, the planning and zoning commissioner, am trying to do my job and ask clarifying questions to the city staff relevant to amending the plan. I would like to show that video at this time, Natalie. And I obtained that video from a YouTube that somebody else has created, but I think it summarizes that night on February 14th very well.
So to that end, that particular date and time of that meeting is not what is in the purview of this complaint at this time.
Okay, but everything that you pulled and you posted on city website relates to those meetings. So if that's the case, why was all that evidence pulled? I think I should be able to show it. I was told I can to bring it with me.
Okay, so it's up to the board to determine whether or not evidence is relevant. The procedures that the board has limit relevancy to what is within the complaint. What is within the complaint is conduct for February 22nd, not the conduct of the Planning and Zoning Commission meeting or of the votes that were taken at that meeting. Now, I understand during some of the testimony that some of the witnesses veered off the rails a bit, but and leeway was given. However, the gist of the complaint is limited to the 22nd of February of this year, and the posting, it's the posting that's the issue.
Okay,
That's the alleged conflict of interest.
I respect your
Not
comments.
the meetings, I'm still talking, not the meeting for Planning and Zoning Commission.
Okay, I would have agreed with that, but you just let Matt talk for 21 minutes related to the vote on planning and zoning. So you're favoring one issue here, but not letting me show what I saw on YouTube that summarizes what happened that night. It's not consistent.
So to that point, we asked for the board chair to speak to give the ethics board just a high level understanding and an appreciation of the role that planning and zoning plays, not specific to the vote and the makeup of those votes. We wanted to understand what role P&Z plays with respect to the city council vote that was subsequent to that. So the understanding that it was an advisory vote versus judicial,
Quasi-judicial.
quasi-judicial vote.
Thank you, Krista. But the vote that was taken that night, he did speak about it.
It's not within the complaint. At this point, I guess the board could vote whether or not they want to watch the video. And whether or not it's relevant to the complaint that's been filed. But it's not the respondent's determination whether or not you see the video, it's yours. It's the board's determination as to what information they choose to accept, witnesses that they allow to testify, and evidence that they choose to hear. Because you're the finder of facts.
I just have more of a question as to why.
Unmute your mic.
More of a question as to why we didn't have the video provided in advance.
My understanding, the video was provided this afternoon to the city secretary. Sometime between,
It was
probably the
11:50.
time I was en route to the city here.
I did mention the video last time, but I wasn't able to. You know, they had said that it had to be sent in previously because it could damage city. It cannot be, like, I couldn't bring my USB.
I'd like to see the testimony that refers to the complaint first. And then see substantiating stuff. Is that possible?
Sure.
That we could do that, because there might be
Sure,
something in that,
Determine relevancy.
sure.
Yeah.
That's fine,
and that way we
that's
can
fine,
proceed and come back to the stuff if we need it.
okay, that's fine.
Does anyone else on the board have comments regarding that?
Now we start with what's most important, most relevant to the complaint, and if that's sufficient, we might need to remove. The exact same one.
This is today. Okay, we'll start with slide 1 on your left. Is a list of documents posted on the city website attached to today's agenda. Is this a frivolous complaint? Was it retaliation or defamation by the city? Number 1, none of these documents posted online with the agenda are related to the complaint. Number 2, none of my responsive documents that were posted on the agenda for public view, including my responses from the April 25th hearing. Number 3, this list implies I violated some other policy. Number 4, this list is defamatory and seeks to find guilt where it does not exist.
So again, we are supposed to be addressing the complaint that was filed and not a general retaliation and defamation by the city. There are provisions in the policy for name clearing that are subsequent to this policy or to this hearing. And what's in front of the board today is the complaint.
Okay. Slide 2, frivolous complaint or retaliation. I'm going to say it because that's what it is. 2 times in this testimony under oath, Mayor Zimmerman attempted to explain his text message to P&Z Commissioner Landine. The mayor first tried to explain when he opened his testimony, and the second time when Ms. Roberts asked him to clarify his understanding of his explanation to the response to Taylor Landine. The text message reads, Taylor Landine, open quote. Okay, I'll skip it. Mayor's explanation of this ethics committees to the board. Quote, I have not weighed in any other, but I'm sharing with you because the comment I made, we're going back to some training. I contacted Lisa Meyer said we had some work to do with the commissioners because they believe they're council members and they cannot take into account public comment or public sentiment or anything else. They're bound by following the 3 documents that they received training on, just like we received training, end quote. On February 14th, I voted no to the Planning and Zoning Commission, and April 25th, when Mayor testified, 70 days have been passed in between. In those 70 days, several planning and zoning meetings have taken place, plus a vote has been taken to a new multifamily development in Lake Point. In those 70 days, no one has reached out to me about additional training for myself, and an open records shows the same for the other 3 members who voted no to amending the land use plan. Mayor Zimmerman testified before the board under oath that his text was not retaliatory, and indeed, it was an inference to doing additional training.
Okay, I'm going to interject again and say that the complaint does not, there may have been testimony, but the complaint is on actions taken February 22nd, not a vote at a planning and zoning commission, and not a text message. So the information that you're hearing is not relevant and is already part of the record and is simply being reiterated and repeated. You want the respondent to continue.
I'm about to explain why I'm repeating this.
I'm asking the board.
Less than a minute.
Okay.
Line that was on.
Did anyone on this board, while this was being done, ask the mayor, where was the so-called meeting, the training done? When was the request for the training? What areas did the mayor want to cover in the training? Who conducted the training? None of those questions were asked to him. He was not drilled like I was. 87 days later today, there has been no training, additional training being requested by Mayor Zimmerman. Slide 2. Mayor's explanation of his text message falls short, falls flat. No training was offered. No training was needed. The mayor must prove the 4 commissioners needed training, or was it retaliation? And the text is there. I'm not going to read it. Number 3. I'm going now to read the open records request made by the ethics, made after the ethics board hearing on April 25th. On April 25th, 2023, Mayor Zimmerman testified before the ethics board. He requested additional training for the 4 P&Z members. The 4 who voted against the Imperial project on February 14th, please provide all details, documents, emails relevant to that request. When was this request made? What was additional training required? The same thing I just said, no responsive
So,
record.
Respectfully, again, I'm happy to hear additional testimony and information specific to the Facebook.
Well, I'm going to do your job right now. So
So-
please do listen to me. Otherwise, you're going to keep interrupting. This is going to take forever.
Ma'am,
Yeah. Okay,
the
so
board didn't ask because it's not germane to their decision. Their decision is limited to making a finding based on the complaint that was filed. The complaint that was
well,
filed.
let's keep going. The city has
Excuse
not.
me, the complaint that was filed doesn't include Public Information Act requests, does not include Planning and Zoning Commission meeting votes. There was testimony adduced, it's already been provided. But the board's determination is based on the complaint.
Okay, but the board information is based on the complaint, but I've seen 2 meetings here where the board has addressed a lot of issues that don't relate to the complaint. So I have to
And
address
which
them.
means this is repetitive.
Mm.
Can you kind of get to the part that addresses the complaint? That's all we're asking.
So this may clarify it, Ms. Patel. Is there stuff that you think was incorrect about the complaint as it was filed versus what you feel motivated the complaint? So
Retaliation is not governed by the code of ethics and is not related specific to the complaint.
So what we're looking at is the complaint. and not why it was filed or who it was filed by, just the details of what it said.
which I have already
And-
gone over with you guys, and,
Okay,
but
is
I
there,
would like this, I would like my time, if I would just can get some time uninterrupted, we can finish this. But the more you're cutting me off from what I have prepared, when I have watched you here for 2 meetings doing exactly, I didn't hear her cutting you guys off. I saw a lot of inappropriate questions being asked by Steve Straley. Nobody cut him off. I saw a lot of inappropriate behavior towards me that did not relate to this complaint. So I should get my time to speak. I don't think it is too much to ask. And the next slide, which you can read for yourself, where I was basically told, in the last statement that Mayor Zimmerman made, that we cannot listen to public comment. And I would like to know where in the city comment documents it says that. The next slide is where the mayor, this is all about the mayor's testimony. I think you're not understanding this. The mayor testified that I believe the filing was based on a screenshot. The mayor has not proved that I mentioned my position on PNC, nor did I share any information that was not public. I have the right to share public information. Krista asked a very important question to the mayor last time. She asked, was the information in the video that was provided by Ms. Patel, was that not available to the public? Meaning, was the average person or any realtor had the same information in the video? The mayor replied, I cannot answer this question. Nobody asked him why. The mayor demonstrated that little knowledge of that video. Mayor must prove I used my position on planning and zoning in the video. He cannot even recall the video. I would like to answer that question for you. The mayor was unable to answer because there was nothing in the video that I shared that was not available at the time to the public. The information I shared was also in the Fort Bend newspaper and the Houston Chronicle. Did the mayor prove that I used my planning and zoning position on the screenshot? No. Did he prove a reasonable person would see the video and connect it to my planning and zoning position rather than my profession? No. Did the mayor prove his text message to Taylor Landine was about my training and not retaliation? No. Did the mayor prove that any of my real estate income is derived from any way from my position on planning and zoning? No. Did the mayor prove the video differs from any other videos I made? No. Why were numerous city documents for today's hearing posted online? It appears this investigation is more about my professional qualifications. Why did the city never post any of my detailed responses online, nor did the documents I submitted to the committee in advance of the ethics board meetings or their consideration? Why does this board continue to investigate aspects of my life that are not related to this complaint? Why did this board fail to investigate mayor's statements? Why is the board trying so hard to prove the mayor's complaint? Where is Taylor Landine today? Why has this committee made no effort to investigate his text message?
there haven't been complaints against the text messages or the mayor.
That was the evidence you had received from me. If you're going to interview Matt, Taylor should have been here. He was involved in the text message. The committee should have been asking, what role did Landine play? And my slideshow is not being shown up there, I guess. Natalie. It would go faster.
Is your slideshow not printed?
I wanted it to show up there.
The board determines whether or not the manner in which evidence is presented. It's
Okay.
up to the board if
Okay.
they want to allow
I-
a PowerPoint.
I did give it so we could show it up there for the rest of the people that are here. Why does he believe 2 others running for council need training? The text message does not end with ... It ends with Landine's thumbs up. Why has this committee not looked into the PNC commissioner who resigned after he attended this hearing on April 25th? Barbara Magana. Why did the mayor fail to provide the original message containing the screenshot via open records? The complaint does not contain the original and it is forwarded message of the screenshot. This committee should ask for the original message containing the screenshot. Another open records request is pending regarding the same text. This committee was steered and participated repeatedly in questioning the legality of the votes by the P and Z commissioners who voted no. My conclusion. The complaint is about a video and specifically how I may have benefited from my position on planning and zoning. There is no evidence to support this claim, only speculation. The actions of this committee to investigate a frivolous complaint has caused one of the 4 commissioners who voted no and sat through the April 25th Ethics Board hearing to resign from planning and zoning. Remove me, find me unfairly guilty. You could be participating in the city-led defamation of my character. This committee should vote to do the right thing. Dismiss the complaint as frivolous based on lack of evidence. See, that wasn't so hard. I skipped over things that, and I made a copy, and I'm glad I made a copy because it should have been shown up there. Had I not prepared, you wouldn't have been having a copy of that either.
Does the board have any questions following Mr. Cal's final testimony?
No.
Okay, thank you. Oh, yes, what about my video? I would like to show it.
Oh, yeah. Reminder, we did say after the testimony that we would determine whether it's relevant to see the video from the planning and zoning meeting. Does the board wish to view that video?
That we're repeating what was presented?
No,
It's entirely-
it's showing some of the similar questions on what we do on planning and zoning and why I'm in the position I'm in right now.
I don't see the relevance.
I don't see the relevancy.
I do not.
Eric? So prior to deliberation, we will receive public comment. Okay. Sure.
It's the microphone here.
Individual number 1, Mr. Kunal. Apologies.
So there are limits on public comment, correct?
Yes. Oh, sorry. Speaker comments are limited to 3 minutes per speaker.
Sure, that will be fine. I think it's- Hi. Hi, good evening, everyone. So my name is Sanjay Singhal. I'm resident of 1214 Brompton Court in Sugarland. So I'm here to speak because I believe, and I have seen this the last 2 hearings, this hearing has gone endlessly in different direction, trying to find fault where possibly none exists. And I think as a resident, I'm quite concerned about it. I'm very glad to hear what you said is that the complaint is about the Facebook post and whether there's a conflict of interest or not. It's not about the vote. It's not about our position at the Planning and Zoning Commission. But all what I heard in the previous hearing today also partly is questioning on those things. And I request really Commission to focus on the matter at hand, which is our
Facebook post which was posted after the city council meeting. And all the commission or board needs to do is answer 3-4 questions. One is, in her Facebook post, does she refer to her position in planning and zoning? And the answer is no. She never even indicate that she is a planning and zoning commission member. In the Facebook post, did she disclose any information which was not available to public? And she did not disclose any information which is either related to planning and zoning or anything which was not available in public. And finally, in her Facebook post, she referred to the city council meeting, which was a public meeting, which she attended as a resident of Sugarland, not as a planning and zoning member. So she learned what she learned as a public, attending a public meeting and put a Facebook post. I cannot see how that can be really be seen as conflict of interest or utilizing her planning and zoning position to benefit her business. As a resident, each resident has a right to pursue her business, pursue her freedom of speech. And if nothing contradictory to her position or in the Facebook post was done, all this complaint and all this time is spent seems like an afterthought, seems like to discourage people from voting the way they want to vote. If the board had actually looked at these facts and these 3 question answers, they would have decided in 15 minutes
1 minute left.
that there is no case to be made against it. However, I have heard endless comments about how many friends you have on the Facebook, how many likes you got, how many share you got. The very many defending thing was about why the vote was wrong. All this you should discard. You should look at the question which I pointed out, which I am sure as a learned member, you will go through those and decide very quickly that there's no case of a
30
conflict of
seconds.
interest because of a Facebook post. And anything beyond is a separate matter. I think the whole of Sugarland is possibly watching this. This has been made more of an issue than it was originally. All the area in my neighborhood all the people are very much now involved and concerned about what is happening. And I ask the board to really do their
10
job, which I'm
seconds
sure you will do very judiciously. Thank you very much.
Ms. Miller, I have to.
Push this button. Yes, please.
Okay, okay. I'm Diana Miller. And I know the recommendation from the attorney here today was that if Ms. Patel had a problem regarding retaliation, that she could file that with the ethics committee, but your ethics ordinances don't allow that. There is nothing in there about retaliation. However, there is a state statute of retaliation of a public servant. And I have filed a complaint with the Fort Bend County DA. So it will go beyond this committee. And what the performance that you gave today, not allowing her to defend herself, only speaks to that retaliation and your defamation and your participation in it.
Next speaker. Apologies, can't quite read.
That must be me.
Here.
Good job. Oh, no, that's not me.
Is that correct? Is there a healing?
The key.
Here.
The key healing?
Okay.
Yeah, she's not.
Just a little more complicated. Thank you. Dakia Hewing, 225 Mileage Way. One of the definitions of retaliation is revenge. Revenge means committing a harmful action against a person or group in response to a grievance, whether it's real or perceived. The perceived grievance, voting no in the P&Z meeting in relation to the Imperial project. We all saw it. Zimmerman texting a council member about how he would deal with them later in the year. His testimony stated that they would ignore the residential opposition to the project and that she needed additional training to do her job. Suddenly, Ms. Patel did not know her job. There was a similar argument last year when the city council voted in opposition to P and Z for the Sugar Creek project. Did Zimmerman request additional training for them at that time? It's something to consider. Didn't he say someone else told him about the Facebook video? Why didn't that person come forward? Did they believe that the mayor's authority alone would convince this ethics committee to act in a manner unfavorable to Ms. Patel? Possibly. While you're considering that, consider this. Unlike Zimmerman, who filed this frivolous complaint, I have watched the video on Facebook. She never mentioned her city affiliation, nor did she go into detail. What she did mention was that information is information that's readily available to the public. I'm sure you're aware the 100 showed up, well, about 100 showed up for the city council meeting, and it did last for a few hours regarding the Imperial project. It was my understanding that any citizen, regardless of their volunteer status with the city, can discuss public information. The city council, all boards, as well as the Sugar Land mayor,
left.
were elected to serve this community and not themselves. Yet time and again, we see the opposite. The ethics committee has a responsibility to uphold the ethic of the city councils and committees and not to pander to its mayor. Have the courage to do so.
Thank you. Ms. Davis?
Hello, my name is Kenyatta Davis, 7500 Branford, Sugar Land, Texas. Thank everyone for being here. Fortunately, we are here. So, I have quite a bit to say. Why did the person that Mayor Zimmerman claims contact him regarding the video not reported as an ethics violation? I wonder who the person was that he referenced. I wonder how Mayor Zimmerman stated in the last meeting that he did not listen to or see the video, yet he made a frivolous complaint file regarding it, which doesn't make sense. I wonder why he is utilizing his position as mayor during every aspect of this, as evidenced by the emails he sent to the city's attorney, because this is not personalized attention the average resident would receive from her. I watched and listened to the video, and it's not an ethical violation. Nothing was stated in the video that was not already a known fact about Imperial from the public P&Z and city council meetings that many people attended in person, approximately 100. Discussed on various social media apps, and is available on YouTube and can be replayed with the same information and more. The city had made exceptions for Puma development that it did not for any other development. So when P&Z voted 4-4, and it caused it to need a supermajority vote, it was very interesting why Mayor Zimmerman only commented on the 4 members that voted in opposition of the conceptualized plan that Mayor Zimmerman and his staff so desperately for a multitude of reasons wanted. So why do the 4 that opposed it get criticized by him, but not those that were in favor of it like him? Why change the land use plan for this particular development? Why didn't the 4 that were in agreement as he was need additional training? Why just pinpoint the 4 that opposed them? That says a lot. Mayor Zimmerman has stated a few times that he doesn't care about the public's comments, which is asinine, since it is just a portion of the meetings that allows residents to speak on and write on the topics. It stated that the city and staff all report to him and make decisions of approval regarding the developments. So I want to know, why is Ms. Patel being retaliated against because she opposed him? That's the thing, it's because she opposed him. Why are they just pinpointing the 4 people that opposed him to need additional training? Why wouldn't they say that for everyone? She did not identify herself as a committee member during the meeting, during the video. She did not receive any type of monetary gain. So I think that this frivolous complaint should be deemed invalid and it should be dismissed as such. I do thank everyone for being here.
10 seconds.
Thank you. Bear with me. Now she.
I'm sorry.
Merhano?
I'm sorry, I'm trying to pronounce your last name.
Merchant.
Merchant,
Yes.
okay.
I'm good to go. Okay. Hi, my name is Afshit Sharanya Merchant. I live at 7343 Chatham Green Drive and have been a resident of Sugar Land for the past 30+ years, which I've known Sapna Patel for the last 10 when my husband and I moved to Telfair, where she served as the HR president. Like Sapna, I'm also a licensed realtor in Texas and a member of HAR. And we are here today about a complaint of violating the Ethical Code of Conduct, Section 277, conflict of interest, which states an official must not use or attempt to use his or her official position or office or take or fail to take any action or influence or attempt to influence others to take or fail to take any action in a manner which he or she knows or has reason to believe may result in a personal or financial benefit not shared with a substantial segment of the city's population. This was what was questioned last time by one of you, I believe. Substantial was the word used. When I sat through the last hearing, this was a comment that was mentioned. I just wanted to highlight that the information in the video that she presented was not privileged, nor was it confidential. The information shared was a vote taken at a public meeting, not in a closed or executive session, but at a public meeting in front of several hundred residents in the room, not to mention all those who had logged on via Zoom. 3, the information shared in the video was also published online in the Fort Bend Independent, because I want to check the date and the time that same night the vote was taken, and also published online in the Houston Chronicle. And 4thly, that she never mentioned her position. She reported it as a resident of the city of Sugar Land. As a resident of the city and someone who volunteers extensively in my community and Sugar Land, I am now finding myself asking the question that had I also posted the same information Sapna did, and been in the unfortunate situation of being appointed to being a city volunteer, say at the position of zoning or board of adjustments or anything else, would this board have also been convened to hold me to the task of sharing information that was held at a public, let me say that again, at a public meeting where a decision was taken by city council and then later also published in the newspapers? Mind you, nowhere in this situation of my hypothetical video
1 minute left.
is my city position mentioned also. Whether Sapna voted for or against development and or increasing the cap for apartments to 1,200 or whatever it is, as a P&Z commissioner, or that city council voted for or against the same, does not affect her, mine, or any other realtor's business. People who like living in high rises and high density apartments and desire for Sugar Land to be more urban will move to Sugar Land. And those who don't will move out of Sugar Land. Those who love Sugar Land having a suburban feel will live here.
30
I mean, if
seconds
that's what the
left.
vote would have done. This is simply a market condition. A realtor's volume of listing and sales comes from their ability, skill set, and reputation. It does not come from sitting on a city board or commission or on how you vote. The same can be said for all of you in this room, in whichever line of business you are in. You're a volunteer resident who are sitting in judgment of a
10
fellow
seconds.
resident today. What you decide today will have ramifications in the volunteer community in Sugar Land and impact residents in their decision to step up and serve our city in the future. So with all humbleness, I ask that you dismiss this complaint and ensure that Sapna's valuable service in
Time's
the
up.
Planning and Zoning Commission is not impacted as a result of what has been shared here today. Thank you.
Sunita Ghosh.
So Sumita Ghosh, 4607 Kennesaw Court, Sugar Land. So last time I spoke and I had basically begged and urged the Ethics Advisory Board to follow the process and look at the burden of proof. And I'm really sad that this whole thing has turned into a farce because facts were not presented. in support of the complaint. And the reason you have to question that simply is because the reason there were no facts presented in support of the complaint is because the complaint is one sentence. It doesn't have any specific referral. One of the board members said, oh, it refers to 2.7 of the blah, blah. It does not. There is nowhere a reference to what part of the code Ms. Patel violated. It does not provide a single bit of written evidence. And I can say all this because I was involved in writing the code. The code specifically lays out what the burden of proof is. There's A, B, C, D. Nowhere in the, because it's one sentence, is there a single fact supporting what part of A, B, C, or D of the ordinance she violated. So simply put, I don't know what you guys are doing here. Why have there not been any questions asked of the mayor about where the heck is this complaint meeting the burden of proof? I don't know. I mean, I'm like, maybe I need to file an ethics complaint or get the city attorney. I know her pretty well. She was there when we wrote the code, where the burden of proof was met in the filing, because her opinion is, in my opinion, this burden meets the burden of proof. I'm sorry, it does not. And any competent lawyer would find that out, because you look at the code, you look at what facts are presented in violation of those specific provisions of the code. And there is none. And you know why? Because he didn't even look at the video. That's why we're all sitting here going, what is what she did wrong? Because we're not supposed to be the ones trying to prove the mayor's case. He literally put in one sentence. Isn't this a violation of the isn't this a conflict of interest? He never even mentioned a violation of the ethics code. He never even used the word code. He just said, isn't this a conflict of interest? How is that a complaint? I'm sorry. And so you just, and then in the back of my mind is, when you get a complaint, it is natural to look at a defense. That's where the lawyer in me comes in. When you look at the defense, it's simply, you can either say this complaint is lacking or that I am not violating any of this stuff. And the defense would be, well, if there was something wrong, why didn't you serve at the pleasure of the mayor? Why didn't he just ask her to leave? It's retaliation. That's her defense. It's retaliation. Thank you.
Thank you. And our final individual.
I'm gonna.
Sri Krishna Venugopal. So it is complicated, so I understand. Yeah, no, I completely understand. Good afternoon. My name is Sri Krishna Venugopal. I live at 4515 Wentworth Avenue, Sugar Land, Texas. I want to thank the Ethics Committee for giving me this opportunity to speak. And because of the sensitivity of the issue, we have individuals involved. I'm going to keep my comments brief. The complaint is that Commissioner Patel misused her position on the P&Z Commission to better her business based on a video that she uploaded. I strongly believe that the burden of proof has to be a lot higher than a video was uploaded. There is nothing. I think you folks have walked and sat through a lot of testimony, information, but nowhere has anyone shared anything which says that Sapna Patel, the realtor, Sapna Patel, the individual, had a financial gain from this video or from her position on PNC. She posted some information that was publicly available. I have not seen the video. I did not need to see the video. I already knew because it was publicly available. Now, the other point I wanted to make is that you folks have a very important task to perform this evening. Primarily because our form of governance is based on the people's representative, whether they are elected as commissioners or appointed, whether they're elected as council members or appointed as commissioners They are the ones who provide governance to the executive, the city staff. And we rely on that. The community members rely on that, okay, to make sure that the tax-paying citizens' interests. are
1 minute
protected.
left.
Okay. And so when the community has to be extremely confident and assured that when their representatives vote, they take a decision. It's based on the facts and the matter in front of them, and not because of incidents or issues such as this, okay? Because there should be no fear in them that there's going to be
30
any
seconds.
repercussion, as long as they are doing the duty and following the process. This is very important to ensure that we have citizen participation in the community. You're all volunteers. I appreciate your time, okay? So please do the right thing. Thank you.
Thank you. That concludes public comments. The board here will now deliberate on what we've seen the last meeting today, and have discussion, deliberation on the complaint itself.
So before you do that, it would be helpful to read what your responsibility is under the policy. Your deliberation is occurring in open session as previously requested by the respondent. In making your decision, it's the province of the board to ultimately determine the relevance of any particular evidence presented, the credibility of any testimony or evidence presented, and the weight to be given to any particular testimony or evidence. You are to determine whether or not a violation of section 2-77 of the city of Sugar Land's city code, conflicts of interest, has occurred as alleged. In other words, did the respondent, as alleged in the filed complaint on February 22nd, 2023, in making her social media posts, use her position as a public official or attempt to use her official position, or did she influence or attempt to influence others to take or fail to take any action in a manner which she knows or had reason to believe may result in a personal or financial benefit not shared with a substantial segment of the city's population for any of the following persons or entities: the official, if it was relative, or the employer or business of the relative, or a person with whom the official has a financial or business relationship, including but not limited to an outside employer or business of the official or the official spouse or domestic partner, or someone who works for such outside employer or business, or B, a client or a substantial customer. Number 4, a publicly traded company. If the official or his or her spouse, parent, or child, I'm reading you exactly what's in the city code, owns the stock or instruments of a debt greater than 10% of the value of the company. Or number 5, real property, if the official or his or her spouse, parent, or child holds an equitable or legal ownership with a fair market value of $2,500 or more. 6, a non-governmental civic group, social, charitable, or religious organization of which the official or the official spouse or domestic partner is an officer or director, or 7, a public or private business entity for which the official or his or her relative serves as a director, general partner, or officer, or in any other policy-making position, except if you're appointed to the position by the city. So normally you would entertain a motion and a second and then deliberate.
Are there any more motions from the board?
So a motion would be that you find that the respondent did not commit or you respond, and as indicated in the complaint, it did not violate the city code, section 2-77 as alleged in the complaint, or that she did. Those are two different motions that you could entertain.
So that. I was just looking for clarification because I thought we were gonna do the physical discussion deliberation first.
So you make the motion. So normally under procedural rules, you make the motion, then the second, then you deliberate, then you vote.
So I move that we open the floor. I move that we open the floor for discussion.
You can do it that
We
way.
have to, we don't have to make a motion. We don't have to make a motion first. We can go through.
You haven't adopted rules of procedure. Normally procedural rules, if you were under Robert's rules, you make a motion, then a second, then you discuss or deliberate. But if you wanted to look, because it guides the discussion. And if that motion doesn't, then they vote. And if it doesn't succeed, then you start with another motion in a second. But you can deliberate however you want.
All right, so I'll make a motion that there was no violation.
I second.
Somebody's got the mic on.
All right, so we have a motion. Who's second? Paul.
Well, you need to discuss.
All right, I'd like to open up the discussion if I could. You know, this post was done after the first reading of city council and before the second reading of city council. The approval was given for the general development plan, not the Pondo development plan. So the post didn't look good. There was really a gray area there. It just wasn't a good look for a real estate agent to do it, but I just could find no violation in that. I'd like to push back to the city to create some sort of a social media policy training for all the boards, and for the city council, for all the city to do some sort of a social media policy so we don't go through this again. And that's my comment.
I think we as involved members in the community know what Ms. Patel's position is on the P and Z. She didn't state that anywhere in her video. She didn't say as a P and Z member or as a volunteer with the city. There was no identifying comments in the video that a general viewer would associate her with a position that's covered by this document.
So agree in that capacity. So I found it interesting and, ask questions to the point of what information was provided within the video itself, because there is an item under section 277 that says not shared with a substantial segment of the city's population. So information that was provided, was it shared? Was it readily available to other individuals of the same profession, other peers within the city itself? I also found that, to your point, Mr. Wolf, about there was no reference of position, right? So had the post indicated, as a commissioner on P and Z, talk to me, I know more than everyone else, or what have you, then, that definitely would have made me lean a different direction. But those are the two areas that I found specific to the language that are in our code of ethics as it stands.
And as lots of people pointed out, when this video was posted, that wasn't privy information. It was available to anybody who pays attention to what's going on in the city at the time. So again, I don't think there was a violation.
I mean, I agree. Before I saw the video, I had no idea Ms. Patel was even on the board, and I didn't gather that information from seeing the video and really couldn't distinguish it any different from any realtor video that I see. So You know, I see no wrongdoing in that.
I would agree. I would say that she did not use her position on the board with that information.
And for me, I think just it was important to try to clarify intent. And so there were questions that might have been perceived as colluding with the complainer. But in essence, it was really trying to get clarity on the context of the complaint. And there was some reconsideration of the complaint itself. And there were missing details. And so in the absence of strong evidence to suggest that there was a violation, I would concur with other board members here that there isn't any wrongdoing, evident wrongdoing.
I would agree. I think Ms. Patel had her realtor hat on and nothing else. She never mentioned her position at all. So I don't think there was a clear violation.
And just to add another lens to this too, I think there are differences too, that you'll often see where there's possibly the perception of a conflict. You know, we're a city with high ethical standards. We hold our officials to these high ethical standards. So, you know, while there could have been a feeling of, you know, a perception, when you look at the actual code itself and the language and what it governs, you know, in my opinion, I don't find it to have an actual conflict. We had a motion, and we had a second.
Another point. It was brought up that we asked a bunch of questions to Ms. Patel that lots of people thought were inappropriate, invasive, attacking. I just want to point out that a lot of those answers were information that gave us this opinion, that if we hadn't asked all the questions that we asked, and we just looked at a couple of statements, a couple of pieces of paper, so much of the answer, so many of the answers to our questions provided exoneration and an innocence. And don't think because we're asking questions, we're thinking somebody's guilty. We want all the information we can get.
Yeah, even more important than us finding a person guilty, standing behind somebody and vindicating them, that's what we want to see. We're a group of volunteers as well. And we want to see things done correctly, and somebody that deserves to be vindicated, we want them vindicated.
So let's put this to a vote, an official vote. So we have a motion and roll call vote. All right, thank you. And it's not here, so next on the vote is Raquel. And the motion was to dismiss, just to recall. In favor. In favor. Oh, sorry, let me go in order. Steve Traley. Ted Lee.
Dismiss.
Andrew Wolf.
In favor of dismissing.
Larry LeBoux.
Dismiss.
Chris Crosby.
In favor of dismissing.
And I, Krista Stegler, vote to dismiss. So the motion carries and the complaint has been dismissed. So now the city has voted on the matter. The board will direct the city attorney to prepare a written decision that is signed by the members of the board voting in favor of this decision.
And actually, I'll right.
Okay. And then a copy of it will be sent to all parties involved.
Do we advise Ms. Patel of the name clearing process, or is that?
It's in the policy.
Okay.
Okay. So name. No.
I don't think so.
So just about you.
Yeah, I just wanted to say thank you for your service. What a hard thing to do, but the members of the public appreciate it.
I'm sorry, what was the question? You're still in your agenda. Item 5. And
It's unmuted now. Sorry.
so
I muted it when it was loud.
Okay, so the purpose of this portion, this segment of your meeting is to review a sworn complaint filed with the city secretary. I don't remember the date. It was filed, I think, the day after your last meeting. So maybe on or about
April 25th.
That's right.
April 25th.
Alleging a violation.
Here. Yes, on April 25th. That's correct.
Okay.
I was trying to find.
No, you're fine. Okay, so this ethics complaint is against council member Suzanne Watley. You had previously voted on a separate complaint very similar to this, but at that meeting on the 25th. But that complaint was not notarized and was not it didn't meet the formalities. And so you determined to dismiss it. This one is notarized and meets all the formalities and has, again, a city attorney opinion. So for purposes of your decision today in review is limited to determining if sufficient cause exists to proceed with an investigation or if the complaint should be dismissed. You will not be addressing the merits of the complaint. You will not be receiving any testimony related to the complaint. Your review is limited to the complaint and the city attorney's report regarding compliance. And then afterwards, you will vote, after review and your discussion, you will vote to decide whether the complaint should be dismissed as frivolous or dismissed because the subject conduct was undertaken in good faith reliance on a formal written opinion of the city attorney, or whether the complaint should be investigated.
So similar to what we did last time, I would like to take the very high points on Meredith's memo that she went through. We did this the last time for the other complaint, and in light of some of those pieces of information, let's make sure that we look at the details. But the first item is whether the allegations were made time. Sorry. Oh, you have to remove, or are you?
That's right. You had if my recollection serves, you had requested to be recused at the last meeting. You would again request the chair to indicate that you have a conflict and that you filed request to be recused, and you would leave and come back after they've decided.
So I need to stay out there and they come back again?
Hasta la vista.
Like you go
Well, I think we still have a quorum, yes.
We have quorum without you.
home? I need to come back if I need to come back.
We are happy to have you, but we have quorum without you.
And that's all, that's all that's going to be discussed, correct?
Yes, there are no other items on the agenda after that.
Have a good.
Thank you.
So the record may reflect that.
Yes, that Mr. Traley has recused himself and he is no longer
In the room.
and part of this meeting. Okay, to continue forward on the memorandum submitted by the city attorney in review and response of the complaint received on April 25th. Whether the allegations were made timely, the city attorney concludes that the complaint was made timely or filed timely. Whether the allegations were made against a person regulated under the code, the attorney concludes that the allegations are made against a person regulated under the code. Whether the allegations, if true, might reasonably constitute a violation of the code. The subject line of the complaint is conflict of interest, section 2-77. I'm gonna discuss this part in detail, but we just read every item on the conflict of interest. So unless the board has any questions on that, I'm going to keep moving forward to her conclusion. She states that she concludes that a reasonable person could question the proximity of the business to the proposed imperial development under the conflict of interest provision. And then item 4, whether the allegation or hearing was signed and sworn by the person making the allegation. The attorney concludes that this requirement has been met. The city attorney has issued a written opinion relating to the allegation. On February 21st, 2023, I issued a written opinion to Councilmember Watley regarding the location of her property to the proposed imperial development and her ability to participate in the proceedings. We can look at that in detail after this. I just want to finish this particular part of the memo. Whether the city attorney recommends the IERB dismiss the allegations or conduct further proceedings. She states that she recommends that the complaint be dismissed for the following reason: that the subject conduct was undertaken in good faith reliance on the attached legal opinion. So if we could look at the legal opinion and see what it states. Finding the page. Sorry. Page what now?
25.
The complaint does not meet the following as far as section 2-97 of the code, and the every conduct was undertaken in good faith reliance on the act a legal opinion.
I'm looking for the. Are you in the full agenda?
Yeah, back to the last one.
Oh, so I'm,
Last one.
so
Okay.
is it in this one? That's what I'm trying to find. If
Oh,
it's there.
there, I have it. Last one.
That's what I'm looking for in the 70-page.
Yeah.
So it is in today's paperwork agenda, it is page 25, I believe, correct? It's posted from the previous case, but it's still the same document that.
The actual packet for today, thanks.
No, so I'm looking for the actual legal opinion from Meredith.
Yeah.
Okay, that's page 60. Thank you. So on Tuesday, February 21st at 9:51 a.m., Meredith Reedy sent Councilmember Watley the following. Texas Local Government Code Chapter 211 requires notice to be sent to property owners within 200 feet of a parcel subject to a change in zoning. Chapter 2 of the city's development code requires the same. This requirement is based upon a state law presumption that property owners within 200 feet have greater interest in the change of zoning and that their property will be impacted more than the properties located outside of the 200 feet. Your property is located more than 200 feet from the property line of the proposed zoning change, and as such, you are not required by law to recuse from participation in this item. So that was the, thank you. So, but I do want to, read the rebuttal by Ms. Watley. Excuse me, I'm sorry, by Ms. Miller against Ms. Watley. I'm looking at page 49 of 71 in our agenda. So I just want to make sure I've read all of the city attorney's information. I want to make sure I read and review the complaint specifics as it relates to that. Oh, that might be the wrong one. Hold on. No, it says I'm refiling. Okay. That's right, April 25th. Sorry. We're all good on the dates. Here we go. Having been lost. City attorney states that she issues an opinion relating to and I'm on sub item 2. This statement is incorrect. The allegation was not the distance of Ms. Watley's property, but rather the value to be gained given the proximity. So what, in my opinion, what Ms. Miller is stating is that her concern is not 200 feet around it, it's that the large monetary possible benefit of the development directly on her own business holdings. She says what Ms. Watley would likely personally benefit in the value of physical property. And she references local government chapter code 171, real property and business interest, and states that it prohibits a local public official from voting on or participating in a manner involving business entity or real property in which the official has a substantial interest if an action on the matter will result in a special economic effect on the business that is distinguishable from its effect on the public. There is no other public, in her words, there is no other public property in its close proximity that would be afforded the same economic effect as Ms. Watley's property. A $1 billion development directly across the street would certainly benefit Ms. Watley financially. If council member Kamali, thank you, was refused out of an abundance of caution, it would seem that Ms. Watley should have been refused as well. City attorney may issue the opinion of no. Oh, she's looking at the timing of it, so that it was done shortly before the vote. Okay, so that is the complaint. We've received, the city attorney said it's relevant, but the city attorney has issued a written, excuse me, I'm losing my voice, written opinion that she feels that she was acting on a good faith reliance of the written opinion prior to the vote. Thoughts from the board?
No, I agree. I mean, she did consult the city attorney. So it's not like she was trying to get away with anything. She asked and the city attorney gave her advice and she followed the city attorney's advice. So I don't think that a complaint lodged against Ms. Watley when she followed, she followed protocol and got clearance.
I agree. The city attorney is an attorney and knows the law. And would.
Let me ask
yeah.
you this or make a comment. I heard you. Didn't you? Okay. like something was coming. So. The city attorney, you can attorney me once I say this, is issuing an opinion based on the legal requirements. What our question is, based on our code of ethics and the information within it, does it warrant an investigation?
Okay. So to answer your question, I don't think it warrants an investigation. I do have a question for our attorney. And it's more just to confirm that what is cited, the local government code, chapter 171, the real property and business interests. That is really about laying out potential conflicts of interest and setting boundaries around that.
Okay, so here are your choices. Dismiss as frivolous, number 1. Dismiss because the subject conduct was undertaken in good faith reliance on a formal written opinion of the city attorney, or investigate it. Those are your choices.
I feel like dismissed because she went on a good faith opinion of the city attorney.
Whether or not you agree with that opinion is not within your
Relevant.
Right. Okay, I agree with that dismissal.
Okay.
Are there any motions?
I make a, it's. Let's say we make a motion to dismiss. Okay.
Specifically indicate why you're dismissing.
Okay, I make a motion that we dismiss because the subject conduct was undertaken in good faith reliant on a formal written opinion of the city attorney.
I'll second.
We have a second. Is there any additional deliberation before we all vote?
I do have a
Yes, sir.
question. Was that opinion before they bought or after they bought?
I'm sorry, I didn't hear what.
The written opinion from the attorney, when was that?
It was before he voted. The property,
Before she voted? Okay,
the property was already,
purchased,
yes.
the opinion of whether to vote or not, okay.
See if anyone has any other questions or comments before we vote.
So in the complaint, there's a question made as to how the city attorney determined the property was outside the 200-foot distance mark in such a short time, indicating from 9:33 to 9:51. But well, the opinion that was issued in February that it was beyond that mark. So I don't think that the city attorney ran out, measured that distance in 22 minutes as alleged in the complaint. I think the city attorney made her determination months before the complaint was filed that it was beyond that 200 mark.
So do you want to investigate or?
No, it's still.
Okay, okay.
I've been.
Either we investigate.
No.
Go with all this.
No, I still stand by, we dismiss it.
Okay.
Based on what I said before.
You don't have to have a roll call vote.
Okay, all in favor of dismissal based on the good faith reliance of the written opinion from the city attorney?
Aye.
Aye. Motion carries. It has been dismissed based upon a good faith reliance from a written opinion from the city attorney. And with that, that is the final item of our agenda item. And I would like a motion to.
I make a motion to dismiss.
A second.
The motion will skedaddle.
Yes. All in favor.